Okay. Let us continue our discussion on Philippine Cooperative Code of 2008. Okay, bali nag-stop ako dun sa termination of membership. Okay, sabi ko sa termination of membership, number one, pwedeng voluntary termination. Meaning, pag sabing voluntary termination, the member in his own initiative may terminate his membership. Kasi yung right mo to associate, meron ka ring right to disassociate. Okay, now anong procedure? Okay, simple lang. Ang gagawin lang ng member, i-notify lang niya, okay, yung cooperative within 60 days daw, okay, dun sa board of director. Bigay lang kayo ng notice of termination, okay, dun sa board of director within 60 days daw. Kaya ino-notify mo lang yung board of director na you want now to terminate your membership. Okay, at once na okay, grinant ang inyong okay membership, okay, yung termination of membership, entitled ka for the return of your capital. Pero meron siyang limitation. Okay, hindi kasi pwedeng ibalik yung capital of course nung member, okay, kung mas malaki yung liability ng cooperative kesa dun sa asset ng cooperative. Okay, yan lang yung limitation. Kasi ang sabi dyan, the refund shall not be made if upon payment, the value of the asset of the cooperative would be less than the aggregate amount of its debt and liabilities exclusive of its share capital contribution. Okay? Now, second, yung tinatawag na involuntary termination naman. Okay? Ngayon, magkaiba sa primary cooperative saka sa secondary. Kasi manonotice nyo, pag primary cooperative, ang members niyan is natural person. Okay? Yung individual. Kaya pag ang individual namatay, o kaya nabaliw siya, then lumalabas, terminated yung kanyang membership. Pero pag secondary or tertiary, since mga juridical person to, okay, kasi cooperative din to eh. Kasi ang secondary, ang members niyan, primary. At ang members ng tertiary is secondary. Kaya lumalabas kung juridical person yan, hindi mamamatayan by natural death. But rather, okay, pwede silang magkaroon ng dissolution. Okay, kaya pag na-dissolve siya, okay, o kaya naging insolvent, okay, yung secondary and tertiary cooperative, that is a valid ground for involuntary termination. Now, in case of death or insanity of agrarian reform beneficiary members of cooperative, the next in kin may assume the duties and responsibilities of the original member. Now, ito naman is termination of membership, okay, for just cause. Okay, now, ibig sabihin, ang okay, membership class pwedeng ma-terminate by vote ng majority ng all members ng board of director. Kaya ibig sabihin, if there are 15 directors, kailangan dito ng 8 votes for termination of membership. Pero by the way, yung decision kasi class ng okay, board of director, hindi naman kasi final yan. Kasi appealable pa yan sa General Assembly. Tapos yung General Assembly, they may create a what we call Appeal and Grievance Committee na may terms of office na 1 year. Ngayon, ano ba ang valid cause for termination of membership? Okay, una, yung member daw, hindi niya pinapatronize yung product or service ng cooperative for unreasonable period of time. Pero syempre, what is unreasonable is a question of facts depending upon the circumstances of each particular case. Okay, pero yan lumalabas as previously determined by the board. Kaya ibig sabihin, determine ng board, ano ba yung ibig sabihin ng unreasonable period of time? Okay, 1 month ba? 2 months? 3 months? Okay, 4 months? Or a year na siya? Okay. Pangalawa, when a member has continuously failed to comply with this obligation, kasi as member, may sworn duty ka na i-comply, of course, yung obligation mo as member. Pero dito, hindi naman lang basta mere failure. Kailangan continuous. Okay? Kaya tingnan mo naka-qualify na continuous failure daw to comply with this obligation. Another, when a member daw has acted in violation of the bylaws and the rules of cooperative. And of course, for any act or omission injurious or prejudicial to the interest or welfare of the cooperative. Kaya pag halimbawa, nag-fall siya dito, okay, may valid grounds for termination. Kaya pwede kang ma-terminate, okay, as member by vote ng majority ng all members ng Board of Director. Okay, hindi tayo nakabase sa quorum ha. Okay, majority ng all members ng Board of Director. Kaya I repeat, if there are 15 directors, kailangan nyo ng 8 votes for valid termination. Okay, now, sabi dito, a member daw whose membership the Board of Directors may wish to terminate shall be informed of such intended action in writing. Kaya hindi dito pwedeng oral lang at kailangan may observance ng due process. Kaya bibigyan ka ng opportunity to be heard bago mag-decide ang Board of Directors. Okay, and of course, the decision of the board must be in writing. Okay, and shall be communicated in person or pwedeng through registered mail. Yeah, pwedeng, okay, i-communicate sa iyo yung termination in person or pwedeng by registered mail. At ito ay appealable within 30 days daw sa General Assembly. At take note, ang decision ng GA is final. Pero merong option kasi ang GA na mag-create ng committee, which is an Appeal and Grievance Committee. Okay, at meron 30 days class upon receipt ng appeal ang Appeal and Grievance Committee na mag-decide on the appeal. Now take note na failure on the part of the Appeal and Grievance Committee to act within 30 days upon receipt of the appeal means deemed approval of your appeal. Okay, as sabi dyan ha, pending a decision by the GA, the membership shall remain in force. Kaya ibig sabihin hanggat hindi pa nagde-decide ang okay, GA, okay, lumalabas, existing member ka pa din. Now, kaya mapapansin mo ha, dun sa termination ng membership, ang may final say pa rin yung General Assembly. Okay? Now, kasi yan ay appealable, of course, sa GA. Now, okay, punta tayo sa administration. Title natin is administration. Okay, sabi dito, ang General Assembly daw, ito yung highest policy making body ng cooperative. Tandaan nyo, ang highest policy making body ng cooperative is the GA. Pag sinabing General Assembly, full membership to. Okay, now, okay, hindi Board of Director. At ang powers nila, okay, na pwedeng exercise are those powers stated in this code, meaning yung nakalagay sa Republic Act 9520, yung provision sa Article of Cooperation as well as in the bylaws. Now, what are the distinction between a GA or General Assembly saka yung Representative Assembly? Pag sinabing GA, full membership ng cooperative duly assembled. Okay? At normally meron tayong tinatawag na annual General Assembly sa cooperative. Okay, sa Representative Assembly naman, full membership ng body representative. Kasi bawat representative, kunwari, okay, meron bawat, okay, halimbawa, each sector for instance, nung cooperative, meron silang representative. Okay, kaya yan naman, full membership ng body representative elected in each sector, chapter or district ng cooperative. Now, ano ba ang source of power ng, by the way class kasi nagkakaroon ng representative assembly kung halimbawa yung membership for instance ng cooperative is dispersed sa different chapter or different sector. Siyempre, bawat sector, meron silang representative. Kaya pag magkakaroon kayo ng representative assembly, bawat sector or okay, chapter, meron silang representative. Yun yung full okay, membership ng body representative. Yan yung tinatawag na representative assembly. Pero pag GA kasi, talagang full membership ng cooperative yan. Now, anong source of power ng GA? O, syempre, nakalagay nga dun sa cooperative law, sa provision ng Article of Cooperation, as well as sa provision ng bylaws. Samantalang sa Representative Assembly, ang powers lang nila, between yung source of powers ng Representative Assembly, okay, are those powers delegated by the GA in accordance with the bylaws. Now, okay, ano class ang composition ng GA? Sabi dyan, General Assembly daw shall be composed of such members who are entitled to vote. Kaya ibig sabihin, pursuant to Article 32, okay, I'm referring only to a regular member. Kasi di ba pag associate member, wala naman silang voting rights. Kaya sabi ko nga sa inyo, doon sa share capital, pwede kayong mag-issue ng either preferred shares or ordinary share. Kasi yung ordinary shares, lumalabas, meron niyang voting rights. At yan yung ini-issue sa mga regular member. And for the preference shares naman, yan yung naman yung ini-issue natin sa mga associate member. Okay, kaya dapat mga regular members entitled to vote okay, under the Article of Cooperation and the bylaws of the cooperative. Now, okay, by the way, paki-memorize nga to, okay? Paki-memorize, okay? Medyo parang feeling ko is magandang itanong to sa board exam. Okay, may tinatawag tayong exclusive power ng General Assembly that cannot be delegated. Okay? To a smaller body. Kasi pwede kasi halimbawa yung GA kunwari magki-create sila ng mga different committees. Mag-create sila ng different committees. Okay, at pwede silang mag-delegate ng powers doon sa mga committee created. Pero sinasabi ng batas dito sa Article 33, ito yung mga hindi pwedeng i-delegate okay sa smaller body. Okay, like committee. Kasi ito ay nasa exclusive powers ng General Assembly. Una is amendment ng Article of Cooperation sa amendment ng bylaws. Pangalawa is election ng Board of Directors, okay, as well as removal for cause. And third is the approval ng development plan ng cooperative. Tapos the rest class, pwede siyang i-delegate okay, to a smaller body. Kaya pwede kayo mag-create ng committee, pwedeng i-delegate ng GA dito yung certain powers. Pero ito, I repeat, okay, nasa exclusive powers yan ng GA and therefore hindi siya pwedeng i-delegate to a smaller body. Okay, now let us proceed now sa meeting of the GA. Okay, syempre parang ano rin yan, parang sa corporation setup, may stockholders meeting, meron tayong directors meeting. Now, dito naman, syempre, ang tawag natin, members meeting naman. Okay? Kaya may tinatawag tayong, okay, GA or General Assembly ng members. Okay? Pwede siyang regular or pwede siyang special. Now, pag regular, normally held annually yan. Okay? Yan tawag dyan is Annual General okay, Assembly. Now, kailan to ginaganap? Syempre, on the date fixed in the okay, bylaws. Or if not so fixed daw, on any date within 90 days daw after the close of each fiscal year. Now, by the way, ang ibig sabihin normally ng fiscal year dito, hindi ito yung fiscal year as ordinary understood. Okay? Normally, calendar year yan. Kaya halimbawa, unless of course provided in the bylaws. Pero normally yung fiscal year na tinutukoy dyan is calendar year. Kaya ibig sabihin kung December 31 ang end natin, okay, bali lumalabas January, February hanggang March yan. 90 days daw after the close ng each fiscal year. Okay, sa amin normally, February pa lang eh. Okay, kasi yung sa amin kasi sa cooperative namin, okay, February, okay, nagkakaroon na ng okay, GA or General Assembly. Okay, tapos magkakaroon ng announcement of course ng dividend. Okay, yung share namin sa interest on share capital. Tapos dito kailangan ng notice of regular meeting. Okay, isi-send yan in writing. Okay, by posting or pwedeng publication. Okay, pero doon sa cooperative namin, never pa yata ako naka-receive ng in writing. Pero normally pinopost yan pag pumunta ka doon sa office ng cooperative namin. Okay, doon sa FEU, naka-post yan doon sa okay, office. Or pwedeng through electronic means daw to all members of record. Now, pag special meeting, of course, syempre special meeting yan at any time yan. Okay, by majority vote ng Board of Director as provided for in the bylaws. Pero dito kailangan ng notice of meeting, okay, na at least 1 week prior to the intended meeting. Okay, special meeting shall be called by the Board of Directors daw in compliance with the required notice within, okay, from at least 10% down ng total members who are entitled to vote to transact a specific business covered by the call. Now, failure of the Board of Director to call a regular special meeting within the given period. Kasi baka mamaya ayaw mag-call ng Board of Director ng regular or special meeting. Pwedeng mag-initiate of course ang okay, General Assembly. Okay? Kaya sabi dyan, the CDA daw may order petitioner to call a meeting of the GA. Okay? Pwedeng mag-file ng petition dyan ang okay members. Pero dapat merong at least 10% of all members ng cooperative entitled to vote. Kaya ibig sabihin dapat regular member to. Ibig sabihin normally 10% ng total composition ng GA. Okay, for good cause shown and kailangan ng proper notice required in this code or in the bylaws. Ngayon punta tayo sa quorum. Magandang pag-usapan ng quorum. Okay? Tingnan nyo maigi to kasi magandang gawa ng tanong to. Now, meron tayong quorum ng GA and of course, quorum ng director. Okay? Parang sa corporation setup, di ba, meron tayong quorum ng stockholders and quorum ng directors. Now, ang tanong, ilan ba ang quorum ng General Assembly? Now, pag ordinary cooperative yan, 25% ng all members entitled to vote. So, madaling salita, if there are 1,000 members, okay, regular members of cooperative, para magkaroon kayo ng quorum, kailangan ng 250 members. Now, pero take note pag electric cooperative, okay, bali 5% lang siya ng all members entitled to vote. Kaya kung 1,000 siya, 50 lang. Okay, ang quorum sa electric cooperative. Pero pag cooperative bank, lumalabas is 1/2 plus 1. Kaya ibig sabihin kung 1,000 yung members, kailangan ko ng 500 plus 1. Now, pero may gusto lang akong i-emphasize dito. Pagdating class sa cooperative bank kasi, pagdating sa amendment ng Article of Cooperation and Bylaws, iba ang kanyang voting requirement. 3/4 ng all members with voting right present with a valid quorum. Samantalang sa ordinary cooperative, pagdating sa amendment ng Article of Cooperation sa amendment ng Bylaws, kailangan ko ng 2/3 okay ng all members entitled to vote. Dito 3/4. Actually, pagdating sa mga voting requirement class, kailangan yung memoryahin yung nakalagay sa table. Pero bibigyan ko kayo ng guide. Okay, para madali nyo siyang ma-recall. Sa cooperative, okay, isa lang dyan ang may 2/3. Okay? 2/3 ng all members entitled to vote. Pagdating sa okay, amendment ng Article of Cooperation saka amendment ng bylaws. Papansin mo pati yung amendment ng article saka amendment ng bylaws, same ang voting requirement niyan. Bali 2/3 ng all members entitled to vote. Tapos the rest, puros 3/4 siya, almost 3/4. Okay, tapos pangalawang tatandaan mo, isa lang ang may participation ng Board of Director. Pagdating sa voluntary dissolution, kailangan ng majority ng Board of Director and 3/4 ng all members, okay, 3/4 ng all members, okay, entitled to vote. Okay, with a valid quorum of course. Kaya 3/4 ng all members with voting right present and constituting a valid quorum. Kaya yan ha, ito lang medyo kakaiba na iba yung sa cooperative bank, naging 3/4 ng all members with voting right present and constituting a quorum. Kaya pakitandaan ha, pag ordinary cooperative, okay, 25%. Pag electric cooperative is 5%, cooperative bank is 50% or majority plus 1. Okay, pero pagdating sa amendment ng Article of Cooperation and Bylaws sa cooperative bank, naging 3/4 ng all members, okay, with voting right present and constituting a valid quorum. Now, tingnan mo naman ang quorum ng director. Bali, majority ng members ng board, okay, shall constitute a quorum or the conduct of business unless the bylaw provides otherwise. I-compare nyo nga doon sa corporation law. Kasi ang nakalagay sa corporation law, ang quorum ng board of director is majority ng board of director na nakafix sa article. Okay? Kaya lumalabas, okay, majority na nakafix sa article. Kaya kung 15 yan, dapat ang quorum nila ay 8. Pero sabi no, unless the article or the bylaw provides for a greater majority. Kaya sa corporation law, pwede mong dagdagan pero hindi mo siya pwedeng bawasan. Pero mapapansin mo dito sa cooperative law, pwede siyang bawasan kasi nakalagay unless the bylaw provided otherwise. Now, kaya susundan mo yung provision sa bylaws. Okay, voting system. Sa primary cooperative, okay, ang rule is each member one vote. Each member one vote lang. Pero pagdating sa secondary tertiary cooperative, okay, sabi dito, okay, they shall have one basic vote and as many incentive vote as provided for in the bylaws but not to exceed 5 votes daw. Now, the vote cast, okay, by the delegate shall be deemed as vote cast by the members thereof. Now, pwede ba class ang voting by proxy? Answer, sa primary cooperative is no. Allowed lang siya sa secondary and tertiary cooperative. At ang ibig sabihin ng voting by proxy means allowing a delegate of a cooperative to represent or vote in behalf of another delegate of the same cooperative. Natandaan nyo, pag primary cooperative, proxy voting not allowed. Pero pag secondary and tertiary cooperative, then of course allowed ang proxy voting. Now, ito class yung summary ng voting requirement. Okay? Kailangan nyo siyang i-familiarize. Not necessarily memorize, but kailangan nyo siyang i-familiarize. Pero sabi ko nga, para hindi kayo mahirapan mag-familiarize nito or kung gusto mong i-memorize, pwede mo i-memorize. Okay? Para wag kayo mahirapan mag-memorize nito, dalawa yung gusto kong tandaan nyo muna. Una, okay, isa lang ang may two-third dyan. Okay? Amendment ng Article of Cooperation saka amendment ng bylaws. At pangalawa, isa lang ang may participation ng Board of Director, which is voluntary dissolution. Kailangan ko ng majority ng Board of Director, okay? Tapos, okay, or other officers, okay? Managing his affair verified by its chairperson or board secretary or one of his director, and the dissolution was resolved upon by affirmative vote of at least 3/4 ng all members with voting right present and constituting quorum. Okay, parehas lang yan. Voluntary dissolution where no creditors are affected and voluntary dissolution wherein creditors are affected. Tapos the rest, mapapansin mo, puros 3/4 na siya, okay, ng all members with voting right present with a valid quorum. Okay? Unlike dun sa corporation law, di ba, wala naman kayo makikita ang 3/4 dun. Puros 2/3 naman dyan. Dito sa cooperative law, puros 3/4 naman tayo. Okay? Ang may 2/3 lang yung amendment ng Article of Cooperation saka amendment ng bylaws. Now, isa-isahin natin. Okay? Amendment ng Articles of Cooperation and Bylaws approved by 2/3 vote ng all members with voting rights. Division class. Di ba pag sinabing division kasi, yung isang single cooperative, magi-split siya into 2. Okay? Kaya lumalabas, para mag-enter ng division of cooperative, kailangan ko ng 3/4 ng all members with voting right present and constituting a quorum. Merger and consolidation, okay, 3/4 din yan. Okay, ng all members with voting right present constituting quorum by both constituent cooperative. Okay, delegation by GA of some its powers to a smaller body of the cooperative. Now, di ba may binanggit ako sa inyo kanina class na exclusive powers ng GA na hindi pwedeng i-delegate sa smaller body. Ano nga yun? Amendment ng Article of Cooperation sa amendment ng bylaws. Pangalawa is election ng Board of Director and removal for cause. At number 3 is approval ng development plan ng cooperative. Tapos kasi the rest class, okay, pwedeng i-delegate ng okay, GA to a smaller body yan. At pag nagkaroon ng delegation of powers to a smaller body, kailangan ko ng 3/4 ng all members with voting right present and with a valid quorum. Another is self-dealing director, yung ratification. Kumbaga sa corporation law, pag nag-ratify ng self-dealing director, 2/3 ron, dito naman ay 3/4 naman. Baguhin mo lang, ganun lang, 3/4 ng all members with voting right present with a valid quorum. Another class is ratification of disloyalty of director. Okay? Now, dun sa corporation law, same concept yan actually. Okay? Same concept, voting requirements lang ang pinagkaiba. Kaya 2/3 doon, 3/4 naman sa cooperative. Removal of elected officer. Okay? Bali, 3/4 votes ng regular members present and constituting a quorum. Okay? Pero dun class sa corporation law kasi 2/3 ng outstanding capital stock. Pero mapapansin mo kasi nakalagay doon class is yung section 28 kasi ng corporation law. Okay? Sa BP 68 na naging section 27 naman sa Republic Act 11232. Okay, ang tinutukoy doon is removal ng corporate director or trustee lang. Pero dito, elective officer. Eh, ang problema, sino bang officers ng cooperative? Kasama dyan yung members ng board of director. Okay, members ng committee created by the General Assembly, General Manager, saka yung Chief Executive Officer. Okay, tapos Treasurer, Secretary, and of course other officers, okay, members na create ng bylaws. Kaya yan covered nun lahat, elective officer. Okay, another is voluntary dissolution where no creditors are affected. Dito naman, no creditors affected. Parehas lang ang voting requirement niyan. Bali, okay, majority ng BOT and 3/4 ng all members with voting right present and okay with a valid quorum. Termination of membership. O, di ba pwedeng i-terminate ang membership for okay, just cause mang vote ng majority ng all members ng BOD. Calling of a special meeting ng GA, kailangan ng majority ng board of director or provided in the bylaws. Pag calling ng special meeting ng BOD naman, chairperson or majority ng members ng board. Filing of vacancy in the board of director on the ground other than expiration of term. Okay, majority ng board of director remaining. Majority ng remaining director is still constituting a quorum. Kasi kung wala ng quorum yan, hindi na siya pwedeng i-fill up ng remaining director. Kailangan i-fill up na siya ng General Assembly. Okay, delegation of powers to executive committee, majority vote ng all members ng board of directors. Granting of compensation to director, majority vote ng members with voting right. Placing elected officers under preventive suspension. By the way, ano ba ibig sabihin ito? Ganito kasi yan. Okay, halimbawa, may tatanggalin for instance na officers. Okay, or director. Okay? Ngayon, ang problema, pag may nag-file kasi dyan, okay, halimbawa, officers muna. Okay, elected official. May nag-file kunwari ng complaint. Okay? Siyempre, dapat gawin ng board of director dito, mag-conduct sila ng investigation whether or not may valid cause ba for removal. Ang problema, kung yan ay isang officer, siyempre kung magkakandak ng investigation, pwede niyang takutin yung mga witnesses or pwede niyang sirain dito yung records. Okay, kaya para ma-avoid to, okay, kasi meron ng pending investigation, then we may put this officer into a preventive suspension. Okay, para hindi niya ma-influence yung mga possible witnesses at hindi masira yung mga records. At ang voting requirement to put the officers into preventive suspension para magkaroon ng smooth investigation is majority ng board of directors. Okay, ngayon paki-check nyo nga to. Okay, electric cooperative na naman to. Okay, ang voting requirement natin for registration sa electric cooperative, okay, sabi dyan, the registration of an electric cooperative with authority under this code shall be submitted for approval to the members through a referendum called for the purpose. The required number of votes for registration with authority shall be 20% of all members in good standing. Okay, gusto kong tandaan nyo yan ha, paki-memorize, okay, yung voting requirement. Kasi magandang tanungan niya mga voting requirement na yan. Pero ito nag-apply lang to sa electric cooperative. Now, let us proceed now sa Board of Director. Okay? Ano bang definition ng Board of Director sa cooperative? Sabi ng Article 5 ng RA 9520 means the body, ito yung body. Kaya ibig sabihin pag sabing Board of Directors, they constitute a body. The composition yan, composed of not less than 5 but not more than 15. Entrusted with the management of the affairs ng cooperative under its Article of Cooperation and the bylaws. Now, what are the responsibilities of the Board of Directors? SPD. Strategic planning, policy formulation, and of course, direction setting. Ngayon, composition class ng BOD. Para siyang tulad dun sa BP 68, dun sa corporation setup, not less than 5 but not more than 15. Pero wag mo na siyang i-compare dun sa RA 11232 kasi nakalagay dun is not more than 15 lang. Okay, tapos ang terms of office niya, okay, ang terms of office ng directors is 2 years until their successor interest is elected, okay, and qualified. Kaya lumalabas, dapat elected and qualified yung papalit. Kasi baka mamaya elected ka nga, di ka naman qualified, edi merong holdover period. Kaya sabi ko nga tandaan nyo ha, doon sa corporation law, bali 135, 14 is stock, 345, okay, 34 non-stock, and okay, 5 years for non-stock educational corporation. But in cooperative setup, the terms of office of director is 2 years. Okay? Now, let us compare yung meeting ng GA and meeting of course ng directors. Mapapansin mo sa GA, pag regular meeting is held annually. Kaya meron tayong annual General Assembly meeting. Okay, dito naman, at least once a month. Kaya normally meron tayong 12 regular meeting of director. Okay, sa notice of regular meeting, okay, sabi dyan, either is sent daw yan in writing or pwedeng by posting or publication or through other electronic means to all members of record. Ito naman, any form of notice of course is allowed. A special meeting, of course, at any time to. Ito rin at any time. Pero ito, okay, by majority vote ng Board of Directors as provided in the bylaws. Ito naman ang mag-call is chairperson or majority ng members ng BOD. Notice of special meeting, may nakalagay ditong at least 1 week prior to the meeting. Okay, ganun din dito sa directors meeting, at least 1 week before the said meeting. Now, okay, proxy, okay, sa General Assembly, pwede siya, pero other than primary cooperative. Kasi di ba sabi ko allowed lang ang proxy voting pagdating sa secondary and tertiary, but not with primary cooperative. Pero pagdating sa directors meeting, of course, directors cannot attend or vote by proxy. Kasi mo-violate yung doctrine of delegata potestas non potest delegare. What has been delegated can no longer be further delegated. Kaya bawal ang proxy pagdating sa directors meeting. Now, question, what are the qualification of a director? Okay, kung gusto mo mag-run as director kasi member ka ng okay, cooperative, okay, ano ba ang requirement? Okay, now sabi dyan, dapat meron kang right to vote. That's why, first requirement, you must be a regular member. Pangalawa, dapat you possess all the qualification and none of the disqualification. Okay, at ang disqualification dating dito, kapag ikaw daw ay merong business similar dun sa business, okay, ng cooperative. Okay, hindi ka qualified to run as director. Okay, kasi may conflict of interest. Tapos, isa pang sinasabi dito sa Article 39 na kapag ikaw ay director, hindi ka pwedeng ma-involve sa day-to-day activity ng cooperative. Kaya sabi niya, the members of the Board of Directors shall not hold any other position directly involved in the day-to-day operation and management of the cooperative. Okay, now, by the way, merong exception nga pala dito. Kasi di ba ang rule kasi dapat bago ka maging director, kailangan you must be a regular member. Pero dito meron tayong exception. Okay, kasi sa cooperative daw may by resolution of the board of director. Pwedeng gumawa sila ng board resolution, mag-admit ka ng director or committee member na hindi naman regular member, but rather appointed by financing institution from which the cooperative receive financial assistance daw solely to provide technical knowledge not available within its membership. Okay, sabi dyan, such director committee members not be a member of the cooperative. Kaya hindi siya required na member ng cooperative pero wala tong power, right, nor responsibility except to provide technical assistance lang. O, yan ang lumalabas na exception natin. Kaya dito, hindi siya members ng BOT. Okay? Now, punta tayo sa filling of vacancy in the board of directors. I-compare natin sa corporation law. Sa corporation law kasi, pag mayroong vacancy sa board of director at ang grounds niya is ERI. Nati-recall niyo ba yung ERI? Expiration of term, removal, or increase in number of director. O kaya other than ERI, but there is no more quorum in the board of director. Okay? In that case, only the stockholders may fill up the vacancy in the board. Pero dito naman sa cooperative law, gawin mo lang siyang E. Instead na ERI, gawin mo lang siyang E. Ibig sabihin, pag ang ground ng vacancy is due to expiration of term or other than expiration, but there is no more quorum in the board of director, only the General Assembly may fill up the vacancy in the board. Okay? Kaya yun ha, tandaan nyo ha, E lang. E. Unlike do sa corporation law, dapat ERI, expiration, removal, or increase in number of director. Now, sabi dyan na director so elected to fill a vacancy shall serve only the unexpired term of his predecessor in office. Kasi halimbawa, okay, si A kunwari, okay, ang nangyari, okay, inelect siya. Kasi halimbawa, yung isang director for instance is sabihin natin class na matay. Okay, in that case, kung patay yan, then pwede siyang i-fill up ng remaining members ng board, okay, if they still constitute a valid quorum. Okay? Now, ang problema, si A na namatay, nakapag-serve na siya for 3 months. Kaya ang tanong, ilan na lang yung remaining niya? Okay, yung papalit sa kanya, kunwari si B, okay, pinalitan, okay, ni B si A, okay, through the act of the remaining members ng board. Kasi pwede naman siyang i-fill up, di ba? Kasi ang ground ng vacancy is other than expiration. At ang remaining director, kunwari, still constitute quorum. Lumalabas kung 3 months pa lang yung nasa serve ni A, yung papalit sa kanyang si B, okay, isa-serve pa yung 1 year and 9 months. Yung remaining term. Kasi remember, ang terms of office ng director sa cooperative is 2 years. Now, punta tayo sa threefold duty ng director, officer, and committee member. Okay? Okay, yung natutunan nyo dun sa corporation law, na threefold duty ng director or trustee, yung duty of obedience, duty of loyalty, and duty of diligence, meron ding similar provision under cooperative law. Pero dito, ang covered niya ay director, officers, and committee members. Okay, sabi diyan, any director, officer, and committee members, okay, who willfully and knowingly vote for or assent to the patent and lawful act ng, okay, cooperative. Okay, lumalabas, violation niya ng duty of obedience. Pangalawa, who are guilty ng gross negligence or bad faith in directing the affairs of the cooperative. Okay, violation ng duty of diligence. At he acquire any personal or pecuniary interest in conflict with his duty. Okay, as directors, okay, officers, and committee member. Okay, lumalabas, okay, ang liability raw dito ay joint and severally. Ganon na ganon din sa provision sa corporation law. Solidary obligation. Pag na-violate ang threefold duty ng director or trustee. Ito naman, director, okay, lumalabas, officers, and committee members. Okay, now Article 45. Ito almost meron siyang similar provision din sa corporation law. Kaya nga kung medyo kabisado mo na yung provision sa corporation law, i-apply mo lang yan dito. Pero may mga changes of course, okay? May difference sila. Okay? Pag kinompare mo sa BP 68, medyo malaki yung similarity. Pero pagdating sa RA 1123, to syempre maraming binago. Pero dito mapapansin mo, liable double the profit. Okay, kaya pinulahan ko siya kasi iba yan. Double the profit which otherwise would have accrued to the corporation. Now, sabi dito, when a director, officer, or committee member daw attempt to acquire in violation of his duty any interest or equity adverse to the cooperative in respect to any matter which has been reposed in him in confidence, he shall be liable as trustee for the cooperative, okay? Be liable for damages and shall be accountable for double the profit. Okay? May double the profit rule tayo pagdating sa cooperative, which otherwise would have accrued to the cooperative. Samantalang sa corporation law, hinuhold lang niya sa okay, trustee for the benefit ng okay, corporation. At wala nakalagay na i-account lang niya yung profit by refunding it to the corporation. Pero walang nakalagay na double the profit. Okay. Now, sino nga class ang officers ng cooperative? Dinefine yan class actually sa okay, Article 5, Paragraph 11 ng RA 9520. Pag sinabing officers ng cooperative, sino may mga kasama dito? Members ng Board of Directors. Okay, tapos mga committee members na create ng General Assembly. Tapos General Manager or meaning yung instead na President kasi GM ang tawag natin or Chief Executive Officer. Tapos Secretary, okay, tapos Treasurer and other members daw. Okay? Other offices na create of course ng bylaws. Kaya ibig sabihin kung hindi ka naman nakalagay doon sa bylaws, edi hindi ka malamang officer. Yeah, yun ha. Okay, other position as may be provided for in the bylaws. Now, ito tingnan nyo ha. Okay, sino class yung elected among the members ng board? Kaya ibig sabihin mandatory, dapat kayo ay members ng BOD. Chairperson, saka vice chairperson. Kaya yung chairperson and vice chairperson, dapat they should be members ng BOD. Pero other than that, okay, hindi sila required na okay, members ng okay, hindi sila required class na okay, members ng BOD. Okay, punta naman tayo sa compensation. Now, general rule class directors are not entitled for compensation except for reasonable per diem. Parang same rule sa corporation law na hindi entitled ang director for compensation except for reasonable per diem. Now, pero ang tanong kasi, pwede bang bigyan ng compensation ang director? Pwede naman. Siyempre kung number 1 nakalagay sa sa cooperative bylaws na finifix ang kanilang compensation, okay, at pwede rin siyang i-grant ng majority, okay, ng members ng okay, with voting right present in the valid quorum. Okay, either in a general, okay, or regular general assembly or a special general assembly called for that purpose. Okay, that no additional compensation other than per diem shall be paid during the first year of existence of any cooperative. Okay? Pero by the way, wala tayong rule na 10% yan kasi sa corporation law, di ba, hindi pwede lumabas ng 10% ang net income before tax ng preceding year. Ngayon ito, gusto kong tandaan nyo kasi ito magandang itanong ulit ito. Now, ang general rule, ang directors, okay, saka officers, hindi sila entitled for per diem. Okay? Sorry. General rule, okay, yung director and officers are not entitled for compensation. Pero entitled sila for reasonable per diem. Kaya ang question ko ngayon dito is that, meron bang instances na hindi entitled ang director and officer even for per diem? Kasi dapat yung per diem entitled sila dyan eh. Okay, answer, yes, in two instances. Number one, in the preceding calendar year, the cooperative reported a net loss. Kaya ibig sabihin kung yung prior period nyo, meron kayong net loss, o ibig sabihin, okay, hindi entitled dito ang director even for per diem. Pangalawa, had a dividend rate less than the official inflation rate for the same year. Example. Okay, halimbawa, ang dineclared for instance na dividend ng cooperative, okay, sabihin natin class na 4% lang. Okay? Tapos lumalabas, okay, sabihin natin class ang inflation rate natin, okay, is 6%. Kaya lumalabas yung dividend na declared, mas mababa yung percentage niya kesa dun sa official inflation rate. Kaya lumalabas, okay, yung directors are not entitled for even for per diem. Okay? Normally class kasi, ang mga cooperative, mataas ang dividend rate niya. Katulad yan sa amin, ang dividend rate ng cooperative nasa, dati mga 12% yan. Minsan nga umabot pa ng pumapalo pa ng 14%. Kaya mga 12 to 14%. Pero syempre ngayon, nung last dividend namin ng February, umabot lang siya ng mga 10% something. Pero mataas pa rin compared sa bank. Okay? Meron nga ako nakita before na parang may cooperative eh. Ang kanilang dividend declared is almost 36%. O, di ba? Ang ganda. 36%. Taas nun. Okay? Kaya halimbawa, ang official inflation rate niya is 7%, 12% yung declared na dividend. Normally, yung mga okay, directors dyan, officers, entitled for a per diem. Pero sabi ko nga kung mababa, kunwari, ang dineclare na dividend, sabihin natin 6% lang, ang official inflation rate is 8%, ang baba ng dineclare na dividend. In that case, directors and officers are not entitled even for per diem. Now, okay, punta naman tayo sa self-dealing director, officers, and committee members. Okay, parang same concept class dun sa corporation law. Okay, halimbawa, ito for instance si ABC Cooperative. Tapos may mga directors dun wari dito. Si A, B, C, D, and E. Okay, ang problema si A, nakipag-deal sa cooperative. Yan tawag sa iyo ay self-dealing director. Now, anong rule? Parang same sa corporation law. Transaction between cooperative and the self-dealing director as a rule is voidable. Okay, at the option ng cooperative. Pero pwede raw siyang maging valid if the following requisites are present. Number one, yung presence daw ni A is not necessary to constitute quorum. Second, yung vote daw ni A is not necessary for validity ng act. Number three, the transaction must be fair and reasonable under the circumstances. At kung yan ay officers or committee members, okay, kailangan may previous approval yan coming from the board of director. Okay? Meaning previously authorized ng BOD o kaya ng General Assembly. Ngayon, pag absent yung 1 or 2, okay, voidable. Pero pwede siyang i-ratify ng at least 3/4 ng all members with voting right present with a valid quorum. Okay? Parang same lang ang concept sa corporation law. Ang pinagkaiba nila, yung voting requirement for ratification. Kasi doon sa corporation law, bali 2/3 ng outstanding capital stock, dito naman ay 3/4 ng all members with voting right. Okay, present and constituting a quorum. Okay? Kaya yan yung sabi sa Article 47, when any of the first two conditions set forth in the preceding paragraph is absent, in the case of a contract with director, such contract may be ratified by 3/4 of all members with voting right present and constituting quorum. Actually, madali naman siyang tandaan yung mga voting requirement kasi compare mo lang sa corporation law. Doon kasi puros 2/3, dito naman ay 3/4. Sabi ko nga may 2/3 lang natin yung amendment ng Article of Cooperation sa amendment ng bylaws. Okay, tapos syempre, kailangan may full disclosure ng adverse interest ng director. Okay, and kailangan the transaction must be fair and reasonable under the circumstances. Okay, now punta naman tayo sa disloyalty of director. Dito sa disloyalty of director, may ganyan din na similar provision sa corporation law. Parehas na parehas, di ba? Ang problema lang, eto, you are bound to account double the profit. Nakalagay lang doon sa corporation law, bound kang i-account yung profit by refunding it to the corporation. Now, dito naman, liable ka double the profit. I-account mo double the profit. Sabi dyan, a director daw who by virtue of his office acquires for himself an opportunity which would belong to the cooperative shall be liable for damages and must account for double the profits that otherwise would have accrued to the cooperative by refunding the same. Okay, pero subject to ratification na at least 3/4 ng all members with voting right present with a valid quorum. Samantalang sa corporation law is 2/3 ng outstanding capital stock. Sabi niyan, this provision daw shall be applicable notwithstanding the fact that the director uses his own funds in the venture. Okay. Now, okay, let's take a break muna. Okay. Stop tayo. Next nating topic is yung illegal use of confidential information.